Mr. Sorrenti, good morning.
Good morning, Your Honor. Thank you.
You can proceed.
Thank you. Good morning, Your Honors. To please the court, my name is David Sorrenti, and I represent the defendant appellant Hector Maldonado in this case before you today. This appeal, Your Honors, originates out of the Plymouth Superior Court, where the defendant had been indicted on various gun charges. As a result of that case, prior counsel, just prior to trial, filed a motion with the motion judge, Judge Locke, who allowed a motion for the disclosure of the identity of previously undisclosed witnesses in the case. After the motion to reconsider was denied, the Commonwealth took they filed a notice of appeal under 211-3. At that point in time, a couple of days after filing that motion on February 12th of 2009, a single justice reversed the trial judge's order, or the motion judge's order. So this appeal raises the issue of whether or not the single justice properly reviewed that particular order, and whether or not he erred essentially in granting.
Has it gone to trial? Did it go to trial?
It did not, Your Honor. Actually, from a procedural perspective, it got to the day of trial. A motion in limine was actually filed by the Commonwealth on the issue of whether or not certain evidence was admissible. At that time, Judge Grabeau, who was the
Right. No, I know all that. I just wondered after the single justice whether it went back and went to trial.
No, it didn't. It did not. So essentially, the issue comes before you as to whether or not the single justice actually should have reviewed that particular order. It's obviously our position that
whether he should have reviewed it or whether he should have overturned it.
Well, actually, I think both. From my perspective or our perspective, the question is whether or not this was the type of case that should have been reviewed and not just summarily denied, if you will. In this particular case, it was relatively routine order of the Superior Court that issued. It wasn't anything extraordinary. It was an ordinary type run-of-the-mill gun case.
Well, I mean, what was at issue is the disclosure of the identity of two individuals who the
Absolutely.
Commonwealth contends to be confidential informants.
Absolutely.
And, I mean, I see from the Boston Globe that there were 4 murders in Brockton. I think we understand that this year so far, we understand that there's a substantial risk to a confidential informant were he or she to be revealed. Why is that not precisely what a single justice should be reviewing?
Well, in that particular case, or in this one, there was no suggestion, I would suggest to you, and I was second counsel in after the motion was actually heard, but in review of the record, it didn't seem to me to be a situation where there ever was an argument that the question of the identity of these two informants, if you will, these undisclosed witnesses, were actually, was any concern of their well-being. Now, certainly, there's always a concern. But at the same time, I think in this particular case, Judge Locke weighed those equities and considered whether or not the equities in this case would have weighed in waiving the privilege and erring on the side of allowing the defendant the opportunity to have the identity of the witnesses. So the fact that obviously that's always an issue, it seems to me in Commonwealth versus Madigan and Commonwealth versus Diaz, that's one factor to consider when considering whether or not the disclosure of the informant should be allowed.
If you couldn't, given the trial Judge Grabeau's ruling that you couldn't, hearsay was going to present, the hearsay rules would prevent any evidence coming in that Beatrice had made a threat or had talked about having a gun. Having these informants was going to do you what good?
Well, it would put the defendant in a position where we could then present that evidence. There was no question that prior counsel went to the first day of trial, if you will.
Could present what evidence? What would you do about Beatrice, though?
Well, I think you could certainly present the evidence through the niece of the police officer, Ms. Vasquez. Then you would obviously call, not necessarily Mr. Beatrice, but Ms. Vasquez would essentially testify that she received a call from Beatrice, that Beatrice had threatened her, was coming over with a gun. At that point in time, the neighbor and the nephew, the nephew, I guess was identified as just the nephew, but also this neighbor called Jose would be in a position to say that he saw Beatrice in the neighborhood of Vasquez's mother driving up and down the street and apparently identified that individual. So I think it gets over the hearsay problem.
But how does that put Beatrice together with the gun?
Well, it puts Beatrice in the car where the gun was found a couple hours later. So certainly, this is not a situation where the gun...
And then your client presumably would have to take the stand and say Beatrice left it there. Is that right?
Well, my
I mean,
client...
even without the threat, because I think the threat is the problem about the hearsay problem.
Well, certainly my client is intending to take the stand to deny that he had any knowledge of the gun that was found under the seat of the vehicle. The fact that Beatrice is put into that car just 2 hours earlier presents the hearsay problem. My client certainly can't testify to that, and at the motion hearing, one of the motion hearings before Judge Cosgrove, he testified that he didn't lend his car to Beatrice. So the fact of the matter is he didn't know Beatrice, but certainly these witnesses put Beatrice in the car 2 hours before he was stopped. And those, I think those witnesses get over the hearsay problem that Judge Grabeau was concerned about.
But maybe I'm confused, but your client is trying to say that Beatrice was in your client's car 2 hours before your client was stopped, but yet your client has said he doesn't know Beatrice.
That's true. And then at the
Doesn't
motion...
that put your client in a pretty difficult position? I mean, if he's being cross-examined on the stand this 2 hours earlier, somebody's driving your car who you claim you don't know?
Well, I think if you looked at the entire transcript, it was clear that they didn't ask Mr. Maldonado a whole series of questions that would have ferreted that information out. In this particular case, it's our position that although he didn't know Beatrice, somebody else had control over that motor vehicle. At the time of the stop, Mr. Ortiz was in the car next to him. They made the stop, they made the search, and ultimately they found a gun with no fingerprints on it underneath the seat of the car. My client has maintained, I didn't put it there, it's not my gun, I didn't see it there. So his knowledge, or the knowledge of that gun, ultimately is going to be a live issue at trial. And certainly, given the fact it's constructive possession, I think the way the judge looked at this case, Judge Locke, it appeared that he weighed out the equities and said, without these witnesses, and the same concern Judge Grabeau had, without these witnesses, the defendant won't be able to present his theory of the case.
Tell me exactly how the threat would get in light of Judge Grabeau's order. You'd call the person who overheard Beatrice making the threat?
Who actually received the threat. Apparently,
You can call her anyway, right?
Veronica Vasquez,
But how could
that's
she,
correct.
but isn't that hearsay? I mean, that's the problem, isn't it?
No, I think also if you looked at the transcript with Judge Grabeau, I don't think that he had a problem within the hearsay part of it because he did accept the fact that it could be a state of mind issue as well. His concern was all of the evidence was hearsay. At the time the counsel presented his arguments, it was clear the counsel missed the point that, with all due respect to him, missed the point that this was clearly hearsay. His position was, well, it was in the grand jury minutes. The government relied on it to support their motion to suppress, and therefore it's got to be admissible. And I think it was clear over the 2 days' worth of argument that he even had the understanding that at the end of that argument that it may very well be hearsay, and as a result, he sought to withdraw from the case because he didn't want to essentially harm his client any further. So at that point in time, Judge Grabeau sent the case back to the motion judge on this issue of potentially exculpatory evidence. At that point, they had the argument in front of Judge Locke, and Judge Locke weighed the equities, and I think, in his opinion, quite well set it out as to why he was ordering the disclosure. And certainly, it's a very rare case, I think, at least in my experience, where any judge.
So run it through me again how this would work, assuming you got the identifications of the informants. How would this be presented at the trial in an admissible fashion?
Well, I think the government certainly would put their witnesses up. The defendant would then look to call a couple of police officers that were involved in the earlier domestic violence case. I think those witnesses were already outlined on the pretrial conference report by prior counsel. He then would have also sought to, and I believe Veronica Vasquez was called to testify, as well as her aunt, the officer Vasquez from the Brockton PD. In addition to that, I would suggest the other witnesses would be not only the nephew, but also Jose. Jose was in a position just a couple of hours before the stop of the motor vehicle to see Maldonado's car go up and down the neighborhood, up and down the street where Vasquez's mother lived, and saw him operating this motor vehicle, or at least a passenger in this motor vehicle.
So
that
Jose is one of the people you want, and you say that based on what you know, Jose would testify that he saw Maldonado's car in the neighborhood.
Absolutely.
He personally saw
He
Maldonado.
personally saw it.
With Beatrice in it.
With
With
Beatrice in it.
But he wouldn't be able to say Beatrice had a gun.
He couldn't say that. He said that he saw Beatrice in the motor vehicle 5 times up and down the street, gloves on his hands. And it's unclear as
So
to...
then you could even, let's say you could...
And that Beatrice was threatened to shoot somebody that day.
Exactly. That was the whole reason for the
But
motor
how
vehicle
could you,
stop.
how could you get that in? That's what I'm asking. How would you get the
That
threat in?
threat. That threat is hearsay.
It's clearly hearsay.
Yeah, so how do you get it in?
I think it's an exception to the hearsay rule, quite frankly.
What
I think.
exception?
Well, I think Judge Grabeau had accepted the fact that it was a state of mind type of thing, that it wasn't
State of mind.
apparently Vasquez's state of mind. And again, I'm going by what Judge Grabeau had
Wait,
outlined in
who
the
was
argument.
threatening who made the threat?
Beatrice made the threat to his then-girlfriend
So how is
Vasquez
it
over the
relevant to
phone.
Vasquez's state of mind?
It's relevant to Vasquez's state of mind because she was the one on the other end of the phone taking the phone call from Beatrice saying, I'm going to come over
Why
to your
is her
house.
state of mind relevant to anything in this case?
Because it shows the possibility that Beatrice, who claimed to have had a gun and claimed to have gone over to Vasquez's house and then was seen in the neighborhood, clearly had the opportunity to possess this weapon.
Was the ruling on hearsay presented to the single justice?
No.
So how could the single justice have ruled in your favor if it wasn't presented to the single justice?
I'm suggesting that the single justice should have denied the petition because of the type of issue.
But if you didn't challenge the conclusion that it was hearsay, and if the single justice accepted that conclusion, doesn't that put you in a position where you can't say the single justice committed an error of law or an abuse of discretion?
I'm suggesting that the single justice abused his discretion in this particular case simply because this wasn't a systemic problem or a wide-ranging issue. This was essentially an evidentiary ruling made by a trial court or motion court judge in the Superior Court. And I've suggested, by way of the cases that have been outlined, it seems to me to be more of a Richardson type of case where the court should have looked at it as that, a routine case, not an extraordinary case. Certainly, it's quite frankly the run-of-the-mill case, despite the fact that the end result was a disclosure of two informants or witnesses. It seems to me, from reviewing all the evidence that I've seen, it tends to be more of the witness variety where the police officer who has a relationship with the nephew and who Jose happens to live next to her mother tend to be more of the issue than a question of those people being endangered. Because there's never been a suggestion that, and I indicated in my memo that, or my brief, that seems to be the case, where certainly I think the evidence would be clearly helpful to my client's defense, and it falls within the Rivario and Lugo type of cases.
Thank you, Mr.
Thank you.
Salenti. Good morning. Good morning, Mr. Schules.
Good morning. Laurie Schultz with Commonwealth. Thank you. I think the problem here, or the fundamental issue here, is whether or not this court's review is going to review the entirety of the trial court rulings down below. The Commonwealth filed a motion to strike, which was referred to this quorum, wherein we sought to strike the defendant's brief and his record appendix. And the reason being is that was not what was presented to the single justice here for the single justice's review. And what is on appeal here is the single justice's ruling vacating Judge Locke's order requiring the Commonwealth to disclose the identity of these two informants. So what this
Is there anything in the record that indicates that this person, Jose, wishes to remain confidential? I mean, you're using Rivario as your standard. That requires the individual to be a confidential informant. Do you know that Jose is fearful of disclosure and has asked not to be disclosed?
I do not personally know that, Justice Grants. However, I suggested in my brief that by the very nature that this person and the other person who saw the defendant's car would necessarily be in danger if their identities were disclosed.
Why?
Because the information could be imparted to Joey Beatrice. And we know that Joey Beatrice was wanted by the police.
But that may be, but that you can't extend the privilege of an informant to just everybody who's in danger.
I understand that, Justice Marshall, but the problem is the informant privilege to protect individuals who may be in some sort of danger or their safety
No,
might
it's
be in
to
danger.
protect informants.
Correct. I'm sorry, did I misspeak? It is to protect informants from their identities being disclosed. We know that these informants lived on the street where an alleged domestic abuse victim's mothers lived, and we know that there was a threat to that domestic violence victim. And to put their identities out there could be imparted to Joey Beatrice, who is the subject of that domestic violence more.
But there's a difference between somebody whose name, you know that it's Jose, versus somebody who is a confidential informant who has said, I'll tell you this information, but I don't wish to be disclosed. Do we know that Jose is simply a person whose name, Jose basically, I gather, told a family member of Officer Vasquez about this, and she passed it on. We don't know, do we have any reason to believe that Jose has said, please do not reveal who I am? And if we don't have that, how can we find in your favor?
I believe that was a question posed during a prior motion in which the Carmen Vasquez, who was the police officer, simply identified the people who talked to her as a family member and this Jose person. By implication, I suggest that those informants or tipsters, as I would like to call them, would like to remain anonymous.
No, you can't do that.
Excuse me?
You can't do that because we have very courageous people who act as witnesses all of the time, even though they are in great danger to themselves. You get the benefit of the privilege, and it's a privilege when somebody, as Justice Gans suggested, said, I will give you the information, but I will not do so if you're going to disclose my identity.
I respectfully disagree. That privilege would extend to citizens who are encouraged to impart information to the police officers.
So every time the Commonwealth thinks somebody might be in danger, they can invoke the privilege?
I think this is more than might be in danger. This is a
No,
situation.
every time the Commonwealth makes a determination on its own without being asked by a witness that they might be in danger or will be in danger, they invoke the privilege?
I'm not entirely sure that this is the Commonwealth not wishing to be. This isn't just the Commonwealth's decision. What I suggested earlier, there was an earlier motion, to suppress. Officer Carmen Vasquez indicated that these people wish to remain anonymously. I don't have the information at my fingertips, but it's my understanding that they wish to remain anonymous. And it's.
Could you just give us that, because it makes a big
I
difference.
believe it wasn't a motion to suppress, but again, Your Honor, that was
Could
not
you just
before
file a
the
letter
single justice.
afterwards with the, if you have the transcript? Thank you, because it does make a difference.
And the privilege would extend to citizens whose safety may be in danger, and that is
Not if
really.
they don't ask.
I'm not entirely. I didn't brief that issue, and I would look into it.
Was this argued before the single justice?
No, it was not, Your Honor.
What was argued before the single justice?
What was argued in front of the single justice was the Commonwealth's privilege not to disclose the confidential informants because it bore no relationship to the gun possession charges that the defendant was facing. And the
But if
single
the privilege
justice.
doesn't attach in the first instance, it doesn't matter whether it does or doesn't bear any relation.
The single justice made a ruling that.
It bore no relation.
He did make a ruling that it bore no relation, but he also made a decision that the information only went to Joey Beatrice. It is not relevant to the possession charge with the defendant is on.
Why isn't, I mean, let me just posit this. I accept the hearsay ruling, but if you have somebody else in the car with the defendant at the time he stopped, right?
Mm-hmm.
Ortiz, I think, was the
Correct, that's who he
Okay, so
identifies.
that's one possibility. And then you also have, within 2 hours before that, this other person in the car with white gloves on. I mean, you don't need to get to the threat. It's just somebody else who might have left the gun there.
Well, the defendant has made no showing that he didn't have his car with him that day. He's made no showing to that effect. that
Defendant
he
doesn't have to
wasn't with
make
his
any
car.
showing.
He has an obligation he has a burden to show that somehow this speculation that Joey Beatrice put the gun in the car
No.
is more than speculation.
No, you can argue that to the jury.
He has an obligation, Your Honor, that to make a demonstration to this court or to the trial court that somehow the fact that these tipsters saw Joey Beatrice in the car, somehow Joey Beatrice put that gun in the car, even though there was no showing that Joey Beatrice had a gun with him, no tip that Joey Beatrice had a
Can
gun.
the defendant call Beatrice or Ortiz to
He could.
testify that Beatrice was driving the car 2 hours earlier
He
that
could.
day?
He
There
could.
may be Fifth
And
Amendment
if
problems.
Beatrice says, no, I wasn't, is he entitled to call as a
He-
witness this unknown person who would say, excuse me, I saw you?
What he
I
could do
think
is
then he could
present.
file a motion, then it would be very important to get the unknown witness at that point.
Well,
matter
at
of
most,
style.
even if the informant's identities were known, the information, we have to look at the information. At most, it puts Joey Beatrice in the defendant's car 2+ hours, almost 3 hours prior to the stop. It does not put the gun underneath the defendant's seat, and he was the driver.
What do you make about the other point on which Judge Locke relied, which is that Beatrice had, and I just had it 2 seconds ago, I read it, threatened to shoot someone that day.
That's hearsay information, Your Honor, and as Justice
Well, you say
Spofford,
it's hearsay. Why is it not? If I say I'm going to go shoot you, is that not a hearsay exception for present contention? Such as I am, that case in law school we learned where I'm going to be going to go to the mines, that came in as the present, as a statement of present intent?
but it's the present intent of Joey Beatrice, who's not on trial here.
It doesn't matter. It's still a hearsay exception.
But whose intent? Would it be the defendant's intent? Here's the problem.
No, it
It's that
goes to the
sta-
issue of whether or not it's reasonable for the jury to infer that Beatrice might have had the gun, left it in the car.
But even if he did have the gun and leave it in the car, it's still, first of all, the defendant is saying he doesn't even know Joey Beatrice. He denies it twice, once at arrest and once a year
Yeah,
later at a
but he
motion.
says somebody else had the car 2
He
hours
does
ago.
not say that. He has not made that offer. So we're in the situation where we have a hearsay statement from Veronica Vasquez made to the police that Joey Beatrice told her he has a gun, he's going to come and kill her. And about an hour after that happens, Mr. Maldonado's car is being driven down this victim's street. We have two people that see the car and see Mr. Beatrice in a passenger seat, not even driving. He's wearing gloves as well as the driver. 2.5 hours later, the defendant stopped, wearing gloves, and the gun is sticking out of the defendant, from underneath the defendant's seat. So even
One
if
way
at
to think of
most-
that is if you're sitting in the passenger seat, you're sticking it into the defendant's seat rather than under your own seat. I mean, you're making the closing argument to the jury.
I understand, Your Honor, but it doesn't show that, it still doesn't show that these tips information is relevant to the defense case. It's not material.
If you
for their presentation.
don't have any evidence that Beatrice was in the car wearing white gloves, you don't have any conceivable argument that somebody else put the gun there.
Except that it's under the defendant's seat. I mean, that someone else put the gun in, that's correct. And the defendant has to make some sort of showing that someone else must have put that in the gun. And I don't think from these,
Why can't his lawyer argue that to the jury?
from these,
Members of the jury, you've heard evidence that Beatrice was there with white gloves, very unusual.
because that's third-party culprit evidence, as I state in my brief, that there's limitations to that evidence and how it can come in. And if the defendant wants to put on the defense that someone else did that and not the defense, then he has to show that it's relevant. In cases like Lugo and Diaz talk about that, and Conkley talk to that, and they speak where there's some sort of inconsistencies between the statements that the informants made or some sort of entrapment case, then it becomes material and relevant. But here, where these statements are just that they saw Joey Beatrice riding in the defendant's car as a passenger 2 hours earlier, does not become material and relevant to the defendant.
Aren't we here to review what the single justice did?
Correct. That's exactly what we're here to review. And some of these materials, which I state in my motion to strike, were not before the single justice. So the question is whether the single justice abused his discretion. The Commonwealth asked that the court to say no.
One last question, if I
Sure.
could. The statement that the defendant apparently made that it had only 10 rounds, has that survived a motion to suppress?
It did, Your Honor.
So that will come in at trial?
That would come in. And that's another problem for the defendant is, as he needs to his admission that the gun had 10 rounds goes against his argument that he did not know the gun was there, which is what he needs to use Beatrice for. Thank you.
Thank you.